Good day to all. So today we are going to see a subject called company law. In that company law, we are going to see a very important topic called prospectus. So the topic prospectus is being covered in our unit number 3 according to our syllabus. And the topics which we are going to cover today in the topic prospectus, the meanings, the features and the characteristics of prospectus, forms and contents, misstatements in prospectus, statement in lieu of prospectus, red herring prospectus. So let us see what does actually the prospectus mean. According to section 236 of the Companies Act of 1956, describes a prospectus as any document issued as a prospectus and includes any notice, circular, an advertisement or other document inviting deposits from the public or inviting offers from the public for the subscription or purchase of any share in or debentures of a body corporate. To make it a very simple, prospectus is nothing but an invitation made by the company towards the public for inviting the public to buy their shares or debentures. So that's why they are mentioned as any document issued as a prospectus includes a notice about the share, the circular about the subscription of the share, advertisement or other document inviting deposits from the public. So company is inviting the public to come and buy their shares or debentures or any other certificates in terms of cash. So what does it prospectus actually mean? It is a document. Basically it is a document. It is an invitation to the member of the public. The public is invited to subscribe to the shares or the debentures of the company. It includes any notice, circular, advertisement, inviting deposit from the public, which we have seen in the previous slide. It is a document by which the company procures its share capital needed to carry on its activity. So why does the company has to invite the public? The basic requirement of the company to have the capital. In order to get the capital, they are inviting the public to come and buy their shares. And in turn, the company will get amount. That amount is considered to be the share capital. Both are being benefited, the company as well as the public. The public is benefited by having the company's share, and in turn they'll get the dividend every year. The company in turn will get the share capital from the public. So next we'll see what are the contents involved in the prospectus. So according to section 56 states that every prospectus must state the matters specified in part 1 of schedule 2 and set out the reports specified in part 2 of schedule 2. So it speaks about part 1 and part 2. So there are two different categories, two different sections in the prospectus. So let us see what is actually involved in part 1. The contents of the memorandum. So it expresses the name of the company, objects, nature of the business, share capital and its division, liability of members, names and addresses of the signatories and the number of shares subscribed by them. So basically it says what the company is, who the company is. So name of the company, what is the name of the company? Objects, what is the motive of setting up the company? And the nature of business, whether they are into production, whether they are into marketing, whether they are into FMCG or oil refinery company, etc. What kind of business they are handling? The share capital, if it is an existing company, what is their share capital they have? What is the value of the business they have? If it is a new upcoming company, what is the share capital they want to be? And its division, liability of the members. So each member's liability has to be mentioned in the prospectus. The names and addresses of the signatories. Signatories in the sense the board of directors, and the number of shares subscribed by them. The next comes the qualification, shares of the directors. So each company have their own board of directors. It is a set of people who runs the company. Basically, they are the backbone of the company. So what is the qualification shares of the directors? If the articles of the company provides that certain minimum number of shares to be possessed by the directors as qualification. In that case, a person shall not be qualified to act as a director unless he holds such number of shares. So from this point, we come to know that each director should hold a required number of shares for them. Only then that particular person will be called as a director after some election process. The number of redeemable preference shares. Particulars regarding debentures and redeemable preference shares with the date of redemption must be stated. There are various different kinds of shares out there. In that, the very important one is redeemable preference shares. So, redeemable preference shares, a shareholder who buys this redeemable preference shares can be redeemed if he doesn't want the shares to be whole. He can just surrender the share to the company itself, and in turn he can get the amount from the company. So that is called redeemable preference shares. Preference will be given to that particular type of shareholders as well as the debentures. So at the time of winding up, the debentures creditors will be settled. In the same case, redeemable preference shares also will be settled. The next is remuneration of the directors and the promoters. Remuneration is a salary. The prospectus must contain the rate of remuneration for attending meetings and for other services of the directors and promoters. So rate of remuneration, the amount to be paid by the company to the directors and the promoters. These board of directors will not be there in the company all the time. Only at the time of decision making and at the required time of to meet, only during that time the directors and the promoters will come and they'll attend the meeting. For attending the meeting, the company has to pay them the remuneration. The names, descriptions and addresses of the directors and the managing director. So the full details about the directors and the managing directors has to be furnished in the prospectus. So the names, address, description, occupation of the director, managing directors, managers and the provisions regarding their appointment must be stated. So as I told you earlier, the directors need not come to the office every day on everyday basis. Only at the time of decision making, only when there is a need, they can come to the office. So these directors' details also has to be furnished in the invitation, which is nothing but the prospectus. The minimum subscription. The minimum subscription on which the directors may proceed to allotment and the amount payable on application, allotment, etc. on each share should also be stated in the prospectus. So what does it actually they are trying to say is, if the company is expecting for 10 lakhs as the share capital, they have to mention the minimum subscription. For example, if they need 10 lakhs rupees and 6 lakhs will be their minimum subscription. It means the company will already inform the register of the company stating that our required capital is 10 lakhs. But if we receive 6 lakhs from the public as a share capital, we will start up the company. So they need not wait for the overall 10 lakhs to be received from the public. So instead, when they get the 6 lakh rupees, they can start the business. The next one is the time of opening. The time of opening of subscription list should also be stated when they are going to open the business, if it is going to be the new upcoming business. The name and the addresses. Name and addresses of the vendors, if any, and the mode of payment of purchase price and goodwill should also be contained in the prospectus. So simply the vendor's details has to be furnished in the prospectus. Underwriting commission, brokerage, etc. Who is these underwriters? The names of the underwriters and the opinion of the directors regarding their financial position and business integrity should also be stated clearly. The names of the underwriters. Who is this in the underwriter mean? We'll take the previous example. 10 lakhs is the share capital. So as soon as the company receives 6 lakhs, they can start the business. The remaining 4 lakhs, if the company finds difficult to get that 4 lakhs and public is not ready to give that 4 lakhs as a share capital, the company will approach these brokers or agents called underwriters. These underwriters in turn will buy their shares or in turn will make arrangement from the public to buy that particular company shares. So for that the company will pay certain commission to those agents called underwriters. This commission is called as underwriting commission or the brokerage. The next is the names of the auditors with their addresses. So auditors' addresses should be mentioned. For every company, there will be a particular auditor. This auditor need not to be an employee of the company or the staff of the company, but the auditors will be an external person who in turn audits the accounting and the financial position of the company. Particular of contracts, the dates and the parties to every material contract and the reasonable time and place of its inspection are also significant. So the contract details has to be furnished in the prospectus. Preliminary expenses. The estimated amount of preliminary expenses to be incurred should also be furnished. Estimated amount, the amount spent towards inviting the public to subscribe the shares. For example, the cost of advertisement, the cost of documentation, the cost of transportation, everything comes under preliminary expenses. The next is the particulars of directors. Full particulars of the nature and interest of every director or promoter in the promotion of or in the property proposed to be acquired by the company within 2 years with statement of all sums paid or agreed to be paid to him in cash or shares for service rendered. So the particulars of the directors should also be mentioned. If it is going to be a full-time director or a part-time director, whatever the nature be, that also has to be mentioned in the prospectus. Disclosure, full disclosure on these matters should also be made in the prospectus. Expected rate of dividend and the voting rights. The right of the shareholders relating to voting, meeting and dividend, along with the nature and extent of restriction to be imposed by articles on their rights to transfer shares should also be stated in clear, convincing terms. In short, everything should be made clear in the prospectus. capitalization of profits and surplus from revaluation of assets. Capitalization of profits, reserves of a company, or if any of its subsidiaries have been capitalized. That is issue of bonus shares. Particular of such capitalization and also surplus, if any, assets from the revaluation of the assets should also be stated. So, what the company is going to do with the profit? That is called capitalization of the profits and surplus from the revaluation of the assets. The next is the inspection of balance sheet and profit and loss account. That we'll see in the next. So that is considered to be the part 2 of it. So report by the auditor. So the auditor has to report its profit and losses, assets and liabilities. So this will be furnished for the existing company. The dividend paid by the company during the 5 financial years preceding the issue of prospectus should also be furnished. So for the past 5 financial years, what was the dividend paid by the company to the shareholders, and the profits and the losses and the current value of the assets and the current liability of the company also to be furnished. Report by the accountant. The accountant should also state a report relating to profits or losses and assets and liabilities on a date which must not be more than 120 days before the date of issue of the prospectus. Misstatement in prospectus. So this is the next topic. What does it mean by misstatement? Misstatement, from the word we come to know it is nothing but untrue information, which is nothing but false statement. So misstatement and false statement in the prospectus are instrument by which dishonest company promoters may practice fraud on the public money. In order to prevent this practice, the law imposes certain duties and liabilities on those persons who are responsible for such issues. If, however, the prospectus contains any misstatement of a material fact, or if the prospectus warns in any material fact, 2 types of liabilities will arise. It means if there will not be any need to collect the subscription or the share capital, but still the company makes an false statement in the prospectus in order to collect the information, in order to collect the share capital from the public, that is considered to be the misstatement. A false information, a dishonest kind of an act. By collecting the amount, that amount will not be used for that particular company purpose, but instead it will be used for some other purpose. So that is considered to be an illegal act. So there are 2 types of liabilities. One is civil liability, another one is criminal liability. According to section 65 of the Companies Act, untrue statement in connection with the prospectus shall deem to include a statement which is misleading in the form and context in which it is included, and omission which is calculated to mislead. So there are 2 kinds of liability. One is civil and criminal. What does it civil need? Certain information may mislead the public, may understand in a different sense. The second one, an omission which is calculated to mislead. Certain information which has to be published in the prospectus, they voluntarily, deliberately they avoid that information. So these 2 acts is considered to be a civil liability. In short, untrue statement means and includes any statement which is not only a false statement but also a false statement which creates a wrong impression of actual fact. Concealment of material fact is also treated as misstatement or untrue statement. So now we are going to highlight the civil and the criminal liability that may appear due to misstatement in the prospectus. So civil liability is explained in section 62 of 1, subsection 1 of the Companies Act states that such persons are liable to pay compensation for any loss or damage which any person may suffer from the purchase of any share or debenture on the basis of the untrue statement. So any public, by giving the information the prospectus, reading the information the prospectus, if he goes and buys the shares of the particular company, and if the shareholder is being misled by a false information, that comes under civil liability. Consequently, a person who has suffered a loss may claim contribution from the others who were associated relating to the issue of prospect until it appears that he was guilty of fraud, while the others were not proved to be guilty. Example, a very simple example, they may give a different company's name and they may collect the issue the prospectus and collect the share capital, and they may utilize it for a different company which may exist or may not exist also. So that is considered to be a civil liability. The next is the criminal liability. This criminal liability is explained in according to section 63 subsection 1 of the Companies Act. Every person who has authorized the issue of the prospectus containing untrue statement shall be punishable with imprisonment which may extend to 2 years or with fine which may extend to rupees 5,000 or both. So any criminal activity which is being undertaken by the people, by the company side, it may go into imprisonment or fine charges. The penalty is also there. The penalty is being explained in section 68 of the Companies Act, provides that a person shall not either knowingly or recklessly by making any statement, promise or forecast which is false, deceptive or misleading, or by any dishonest concealment of material fact induce or attempt to induce another person to enter into an offer, to enter into any agreement. For acquiring, disposing of, subscribing for, underwriting shares or debentures. Agreement, the purpose or pretend purpose of which is to secure a profit to any of the parties from the yield of shares or debentures, or by inference to fluctuations in the value of shares or debentures. Otherwise, he shall be punishable with imprisonment for a term which may extend to 5 years or with fine which may extend to 10,000 or both. So, person who are liable for untrue statement, it speaks in section 62 subsection 1. Every person who is a director at the time of the prospectus, for to whom these liability will go on, for the person who acts as a director there during at the time of issue of the prospectus. Every person who has authorized himself to be named and is named in the prospectus either as a director or as having agreed to become a director either immediately or after an interval period of time. Okay, so person who wants to be a director immediately or wants to be a director after some time, that person will also comes under this act of illegal. Every person who is a promoter of the company, obviously, every person who has authorized the issue of prospectus. So the liability will go to these people. So defense available in action of the prospectus, defense against the civil liability, defense against an available to an expert, defense against the criminal liability. So what is civil liability? No decree for damage shall be passed if the person charged can prove any one of the following. A person who is not liable if he withdrew his consent before the issue of the prospectus. If any person goes out of the consent before issuing the prospectus, that person will not be considered for this liability. And issue without knowledge and consent. If a person can prove that the prospectus can issue without his knowledge or consent, and after becoming aware of its issues, he gave the public notice that the same was issued without his knowledge and consent. So without this knowledge and consent, that he proves himself that he is innocent, that he is unaware of those knowledge, then he will be out of this. to an expert. So after giving an consent, he withdrew his writing before delivery of a copy of the prospectus for registration. So an expert who involved into this kind of act, and he comes out of this consent without before issuing the prospectus, he also not be considered. So these things are speaks in the section 64 subsection 4. Knowledge of untrue statement. If the person, on becoming aware of the untrue statement, withdrew his consent in writing and gave public notice with reasons thereof after delivering of the copy of the prospectus to and before the allotment. So he is competent to make such statement, and he had reasonable grounds to believe and did up to the time of the allotment of shares in debentures believe that the statement was true. So defense against criminal liability, the statement of immaterial, that he has reasonable grounds to believe and did up to the time of the issue of the prospectus believe that the statement was true. So what is actually statement in lieu of prospectus? If a public company does not invite the public to subscribe for its shares but acquire to have money from private sources, it may not issue a prospectus. In the circumstances, the promoters are required to prepare a draft prospectus, which is known as statement in lieu of prospectus, which must contain the information required to be disclosed by Schedule 3 of the Act. So what does its statement of lieu of prospectus means? But acquired to have, the company is in need of money from private source, but it may not issue prospectus. So it already has a source to get the share capital, but it doesn't want to issue the prospectus to the public. So in that case, duplicate, a draft will be submitted to the registrar. So that is called statement in lieu of prospectus. So this is being discussed in section 60 subsection 1, states that the company having a share capital which does not issue a prospectus shall not allot any of its shares or debentures unless at least 3 days before the allotment of shares or debentures there has been a delivered to the register for registration in a statement in lieu of prospectus. So these are the conditions for that. What is red herring prospectus? So red herring prospectus is a document which is submitted by an issuer company who intends to have public offering or securities. It is associated with the initial public offering. So it is submitted by the issuer who intends to have public offering of securities. Securities is nothing but the shares of the debentures. It must be filed with the Securities Exchange Commission. The term red herring comes from the tradition where young hunting dogs in Great Britain were trained in order to follow a scent by the use of the red herring. It is interesting to note that the punget fish would be dragged across a trail until the puppy learned to follow the scent. It is nothing but a tradition how the word red herring has comes. It is basically, it's all about initial public offering, so which will be registered with the Securities Exchange Commission. So what are the contents in the red herring? Purpose of the issue, proposed offering price range, promotion expenses, copy of the underwriting agreement, underwriter's commission and discount, disclosure of any option agreement, balance sheet, net proceeds to the issuing company, earnings statement for the last 3 years, legal option of the issue, copies of the articles of incorporation of the issuer, name and addresses of all officers, underwriters, directors and stockholders owning 10% or more of the existing outstanding stock. So these are the contents to be published in the prospectus, red herring prospectus. So commencement of the business, it speaks about a private company need not go for the share capital because they collect the share capital from their own source of income. The public company, as soon as the prospectus is issued and as soon as they get the required amount, that is, for example, the last example what we have discussed, if the authorized capital is 10 lakh and if they issued 6 lakh, they can start the business. So that is called commencement of the business. As soon as they get the required share capital, they can start the business. So section 149, it must not commence the business under certain reasons. The minimum subscription has not been raised. If the company have not received 6 lakh, yes, that can be done. Every director has paid to the company on any shares he has taken up on application and allotment. Only application allotment is being made. During that case also they cannot start the business. No money is repayable for failure to obtain stock exchange recognition for the shares where such recognition was promised. Declaration made by the director or the secretary of the register stating that the fact that the above requirement has been duly complied. Section 149, subsection 2 is also issue a prospectus should not commence a business. It has filed a register. When the prospectus being registered with the registrar, then also they cannot start the business. Every director has paid the money due from him. The director is also liable to pay the share capital. Declaration made by the director or the secretary to the register stating the fact that the above condition has been satisfied. As soon as they receive a document, a written letter from the register, then only they can start the business. So if the foregoing conditions have been duly compiled with the register, you will certify that the company is entitled to commence business, and it is in exclusive evidence that the company is now entitled to commence business. So after getting a duly compiled letter from the register, they can start the business. If any company commences business before obtaining the certificate of commencement of business, so it means the register has to give a letter. That letter is nothing but certificate of commencement of business. A public limited company should get the certificate of commencement of business. Only then they can start the business. That is, in contravention section 149, every person responsible for doing this is liable up to fine for rupees 500 per every day. Like every day they postpone the commencement, 500 rupees will be charged by them. So this is that's all we have discussed about the prospectus. I think everyone have a clear picture about what is actually a prospectus mean, and what is red herring prospectus, misstatement, and the contents available in the prospectus. Thank you for listening. Thank you. Have a good day.